Drilling noise while I'm speaking.
I just went ahead and started the recording, and then as soon as it hits 1 o'clock, I'll go ahead and start the webinar and then start the webinar video. We're expecting about 200 people to come on for the live session today.
Nice.
We had 500 register.
Oh, wow. It's funny. Might help.
Okay, we're going live. Good afternoon and welcome to the Brokers and Managers Forum, another installment in the Maryland Realtors webinar series. Today's forum features from Maryland Realtors CEO Chuck Caskey, President Dee Dee Miller, our Government Affairs team Susan Mitchell and Bill Costelli, the Director of Professional Development and Member Engagement Colette Massengale, and a member of our legal team Kathleen D'Artez. As you have questions, please place them in the Q&A box and we will attempt to answer your questions at the end of each segment. Thank you again for coming, and we will send a recording of this webinar to you in the following week. For now, it is my pleasure to introduce Dee Dee Miller.
Thank you, Adrienne. Welcome everybody today. I am Dee Dee Miller and I am the President of Maryland Realtors, and I am happy to welcome you to the 2021 Broker Manager Forum. As leaders in Maryland's real estate industry, you know well the challenges agents, homeowners, and buyers face each day, particularly in this strong market we're currently experiencing. You also know that being prepared and informed is also the only way to meet those challenges and be successful. We hope today's webinar will give you a good picture of the following: activities of Maryland Realtors, some of the new laws and legislation in the news, upcoming changes to the Maryland Residential Contract of Sale, and hot topics from our legal hotline. As President of Maryland Realtors, each year we enter the year with initiatives that will help to guide the association along with the help of our strategic plan, as well as reviewing the market and the needs of members. One of my initiatives this year has been to offer webinars to focus on agent financial wellness. 3 webinars featuring nationally recognized speakers discussing topics such as business planning, financial investing through not only investment properties, but retirement as well, something that is generally overlooked by agents in our industry. The webinars have been well attended, and if you missed anything from any of those webinars, there were 3 of them. All of them are on our Maryland Realtors YouTube channel, so please check those out. They're there for your future viewing and actually content that you could use for your office meetings. So check those out when you have a chance. There's actually, besides those webinars, there's quite a bit on the YouTube channel available for use. So it's great. So as you know, as managers and brokers, regular evaluation of your structure and processes is a must. At Maryland Realtors this year, we also felt that we were in need of some restructuring. In early 2021, I appointed a group to review our association's bylaws. This process consisted of multiple meetings, which resulted in the changes that were presented recently and voted and accepted at the May Board of Directors meeting. One of the most notable changes was the restructuring of the composition of the Board of Directors to include 2 representatives as recommended from our newly formed DEI advisory group, as well as a representative on the executive committee. Finally, I would like to mention that this year's events committee has reimagined the conference. It is back in Ocean City. It is October 12th through the 14th. There was information for registration in today's hot sheet, so please encourage your agents to attend. We have a great lineup of speakers and events for the conference this year, and it will prove to be an exciting event, and I look forward to seeing you all there. Today, our first speaker is Maryland Realtors CEO Chuck Caskey. Chuck was the former Vice President of Legal Affairs for the association and has had a career that spans real estate closings to serving as legal counsel to the Maryland General Assembly and helping run one of Maryland's largest local governments. Chuck will be giving you an update of the association's activities and plans for the future. Chuck?
Thank you, Dee Dee, and welcome everyone. We're glad to bring this information to you in this format. I guess one of the most important things to remember is that this is the future. The future's now. This is the new normal. This is the now normal. And we talked about this even internally. It's pretty clear to everyone that, number one, this is how we're going to do business from now on. Number two, it's going to change. So we have to incorporate whatever happens, whether, talk about the Delta variant. Well, check out the Lambda variant. There are so many unknowns. And that's the key takeaway for us as the association, that we just don't know. And change is inevitable. We can prepare the best we can for a lot of different alternative realities as we've encountered them. But it's important for us to remain flexible and resilient. And I have to tell you, Dee Dee embodies that as a leader. She has come into this role not knowing what to expect. And she is the epitome of a person who takes what she has in front of her and makes the best of it. So Dee Dee, thank you for leading us for this year and the rest of your year. It's not over. We have a lot even to accomplish before the end of your term, but just want to express our gratitude, the entire staff and Maryland Realtors in general for your leadership. So thank you. Thank you so much for that.
Thank you. I appreciate that.
When we look at, again, what we are going to look like, at least for the foreseeable future, we need to adopt and adapt continually, which we have. We are going to be a fully hybrid organization beginning with our next elective and committee year that starts October 1st. We are implementing new technologies. Our IT director, Michael Cunningham, has done an outstanding job working to not only have committee meetings that are fully engaged, or that will fully engage our members, whether they're going to be present at our building or attending remotely. We are also, Michael and Colette are working to get and implement best practices for virtual CE, and I'll let Colette address that as well as the contract stuff, Colette. I'd like to talk a little bit about what, for example, GRI is going to look like in the hybrid setting. I think that's important for people. And associations around the state are doing it. Your local boards are doing it. And what we find is, interestingly enough, that member engagement actually goes up, and the ability to attract our members from around the state and have them fully engaged in our structure, in our governance structure, in our committee work, and our board of directors, and not have to travel to Annapolis, whether it's from Garrett County or Cecil County or Southern Maryland or Ocean City or anywhere on the Eastern Shore, to save you that time. You can be fully engaged. And NAR has experienced this. Member engagement is way up at the national level. And our engagement is way up. And we intend to make sure that we continue to accommodate that ability to engage with us as full functioning members of our committees and our governance structure, whether you can travel to Annapolis or not. And I think that's really important. And we've already received very, very favorable input from our members about that. And we're going to expand those opportunities this year. And I don't see any reason to go back. And I never liked the phrase "the good old days" anyway, because generally they weren't good, and they were just old. And so I have no no necessarily great fond memories of people. We had members from Garrett County, for example, drive 2.5 hours one way for a 2-hour meeting and then 2.5 hours back. And we loved seeing them, but it was an impediment to full engagement. And so we're breaking down those barriers. And I'm very, very excited about those opportunities for all of our members around the state. In addition to that, about 4 years ago now, I committed to making us, at the time, the phrase I used was data-driven organization. And what we mean by that is not unlike you all do. You run your companies, you have your metrics, you get your data, you look at the data to help you make better decisions. And we've accomplished a lot of that. Bill will talk a little bit when he talks about the Open Doors program initiative that we've launched. Part of that is gathering a lot of data about not only Maryland and what the demographics of Maryland looks like, but what our members are thinking and what our membership looks like. And I have recently come across a phrase that I have adopted that I like even better, and it's called an insights-driven organization. And what that means is, what good is data without the insights that that data provides you? Because the whole point, right, is to make better decisions, to make better and more informed decisions. And so you take that data and that gives you insight into the kinds of things that you want to accomplish and how to accomplish those. So it's not just decisions, it's looking at the data, kind of asking, what is it telling me? What is it telling me? What kind of insight can I draw from that? And then how does that inform our decision-making moving forward? And I can tell you one major outcome that I would like to see from these efforts. And there's 3 parts to it. Number one, what does the state of Maryland look like demographically? What is our makeup? And we know it's in the census data and it's gettable, and we've gotten a lot of that. And so what does Maryland look like? And then, not just age, national origin, all of those things, racial makeup, all those things. And so ideally, we would have a representative membership. So in a perfect world, in my perfect world, Maryland Realtors looks like the state of Maryland. And right now, I can tell you it doesn't. There are far fewer, proportionally, for example, far fewer Hispanic realtors than there are Hispanic members of Maryland in the general population of Maryland. That's just one example. We are underrepresented in real estate. The Hispanic community is underrepresented. And that's just one example. We have others. And so we then draw from that some insights. Why, number one. So now, but we need to know, and now we know what questions to ask. Why isn't real estate an attractive profession for Hispanics? And so if we can answer that, we can do outreach and say, hey, you know what? Consider real estate as a profession, because we also do know that the home ownership rate for Hispanics is pretty high, and so there's built-in consumer base and client base for a person who wants to enter the business and can generate a good book of business. So we want to look at that, and if there are other populations that are underrepresented within the realtor community and the realtor profession, then we can do some outreach and boost those numbers. And then we're going to look at Maryland Realtors governance structure. We've already, as Dee Dee mentioned, addressed some of those concerns, but we have a long way to go, not only in our board of directors and our executive committee, but in our committee structure. Does Maryland Realtors committee structure mirror our membership? And we already know, ideally, our membership would reflect, population of Maryland, and then our governance structure would represent our membership. Ergo, our governance structure represents the state of Maryland. That's where we want to be. And I think that's a place we can get over time, but we need that data and we need those insights to tell us where we're falling short so that we can address those issues in a way that makes sense and it's targeted and effective. And so we are gathering all of that data. We're looking at it to gain insights into the kinds of things that we need to do. And that's just one example. But the first thing is, the question is when you start gathering data, the first question is, what are you going to do with it? Why are you getting this? What questions are you looking to ask of the data? And so that's just one example. But I do think we'll be a much healthier organization over the next few years as we better reflect our membership, and most importantly, I think that our governance structure better reflects our membership. And we did a lot of outreach this year. Dee Dee mentioned the DEI advisory group, and I know they did outstanding work encouraging members from multicultural real estate groups who maybe hadn't considered getting involved in state committees, for example, or in our governance structure in other ways. And so we are making good progress. There's a lot of work to be done. These are long-term commitments that we are making so that we increase the level of diversity, equity, and inclusiveness in Maryland Realtors, and we're better serve all of our communities when we do that. So that's a huge part of the initiative. Dee Dee's been extremely important. John Harrison, previous president of Maryland Realtors, began that process, and we are actually seeing some significant results from that commitment. So congratulations to Maryland Realtors leadership for supporting that, and thank you all for supporting that. Some of the other things that we have done, we revamped our communications department, including Adrian and Dan Petrell and Josh Woodson, our communications team. And they've done just an outstanding job. If you get communication from us of any kind, you know that it looks different, it looks better, it's vibrant, it's more consistent. It's chock full of information that you can use. The redesign of the magazine, the redesign of the hot sheet, so many other of our communications channels are so much more accessible and robust. And so we're very proud of all of our communications efforts, including our new not so new podcast that is actually doing pretty well. We started out twice a month, and that was a little bit tough. So we're putting it out once a month, and we have a pretty decent following on the podcast. So please check it out wherever you get your podcasts, Buzzsprout or Apple Podcasts or wherever. We're on all of the podcast distribution channels. It's called Get Real Estate, Maryland Realtors Podcast. And actually, if you say, hey, Alexa, play Get Real Estate, she will play the most recent episode of the podcast. Speaking of smart speaker skills, we do also want to adopt, Alexa's responding to me right now because I said it in front of her. So now she's playing the podcast. I may have to turn it off. Alexa, turn it off. Yeah, she started playing the podcast. So anyway, sorry you had to hear that. So anyway, what we do, our next goal is to adopt or to implement smart speaker skills. And so those will be very quick. Yeah, that's right. Alexa's obedient. So we do want to have also smart speaker skills, and those will be real quick hits. Just, hey, what's going on at Maryland Realtors? I'll use Google so she won't respond. Hey, Google, what's happening at Maryland Realtors? And it'll be populated with that week's events or the upcoming events, and maybe a legal quick hit, or something from one of our other departments. Hey, look, check this out, or whatever. And the purpose of all of this, and something that Dan and I agreed to when we brought Dan on board, was we are in all of the above mode. Then that's what we do, and we have to. Our membership, it's been said to me, and I think it's true, represent 5 generations of people are represented within our membership. And that means that people are going to get their information in vastly different formats and directions. We have proposed eliminating the magazine, for example. A lot of publications don't do anything but an online version. I mean, you probably subscribe to what used to be print magazines that are only online now. When we surveyed our membership and asked them about that, the overwhelming response was, no, we love getting the magazine 6 times a year. It's the first thing I look at it. And then I look for the legal hotline article, and I look for this and I look for that, and I use it. It's information, and I bring it to work, and I can carry it around with me, and I can look at it. And so we have a lot of members who want that tactile, printed document. And so we're going to continue to do that. But we're also going to put it online and make it much more interactive, things like that. We have a very robust YouTube channel where things like this webinar will appear. Also, a lot of the seminars that we've given, a lot of the videos from the legal department, et cetera. And so, we have some short ones and some longer ones. So if you want your information in half an hour, or an hour, you can get it that way. If you want it in 6 minutes, you can get it that way. If you want it 25 minutes, you can listen to the podcast. And pretty soon, if you want it in a minute and a half, then you can get it off of your smart speaker. And so that's our philosophy. It's an all of the above. We need to reach our members where they are and provide them information in formats and in time lengths, et cetera, that they find most accessible. And so we are listening to you. If you have other thoughts, just please let us know, or we need to respond to the needs of our members. I'm seeing a couple things in the chat. Somebody does like the magazine. Yeah. So the last chat was, the legal information, and it's a very good opportunity for learning, and a lot of brokers and managers like you all use it, hopefully continue to use it in your weekly or monthly meetings. The last thing I want to touch on is just one success that we had going back to technology. Probably should have fitted in earlier, but kudos to the Government Affairs Department, specifically Susan Mitchell, who is our liaison to the Real Estate Commission. We were concerned, given how successful virtual CE was, and the fact that we were planning to continue to offer a hybrid model of CE with some people present in the room and some people attending remotely. The initial approval for virtual CE was given to the Real Estate Commission through the executive order establishing the state of emergency. And we were concerned that with the impending ending of the state of emergency, that the authority to provide virtual/hybrid CE would also expire with the state of emergency. So we asked the Real Estate Commission and their attorney to look at the existing regulations and laws concerning continuing education to determine whether a rule change, whether it's a regulatory change, hopefully it wasn't going to require a statutory change because we wouldn't have that till next spring sometime. But they determined, thankfully, that we could continue to offer virtual/hybrid CE under their existing authority. And so we are extremely pleased with that. And Kathleen and Bill did a great job. Susan did a great job of shepherding that through the commission process. And they came out with an official position that, in fact, yes, as long as we are following the rules regarding signing in and checking identities and verifying identities and monitoring the class to make sure that people are actually participating and not driving and carrying their phones around. And God knows you all have seen it. If you've been in these classes, you've seen some behaviors that kind of leave your head scratching. And I will say that one of the things that we are stressing internally and talking to our local boards about is to maintain that order and that consistency. Because if, in fact, we see that, or the commission, I should say, sees that we're not taking that seriously, they're gonna pull that authority from us if we take advantage of it. If people aren't paying attention, if they're turning their cameras off, if they're not responding when the instructor asks for them, or the monitor, seeks some input from them and they're not there, So we do control our destiny when it comes to that. And we're excited to continue to offer that. And we know that people have been taking advantage of it, people from all over the state. I know that Kathleen and Colette can speak to this as well. People, teaching a class sponsored by the Mid-Shore Board, which have people from Garrett County attending. And so we know that people are taking advantage of it, and it's only going to get better. So that's a real quick overview of the main initiatives. I'm sure everybody else has additional things. And any other questions for me? I think we should have mentioned that if you do have questions, ask the speaker while they're speaking. We can always go back to the end if we need to. But otherwise, if you have any questions specifically for me on that or any other topic, I'll give you a minute or so to type. Otherwise, we'll move on. But any other questions, comments, concerns for me specifically at this point? Linda Harned has her hand raised. Linda, we gotta ask you to type it into the chat or Q&A, if you don't mind. It gets unwieldy if we have, I know you wanna, but we'd rather do these, hopefully written questions. Linda and somebody else who raised their hand. Don't be shy now, or come back, we'll come back. Type your questions in either the chat or the Q&A, and we'll answer them, as we can. Oh, there it is. Okay, great. Thanks, Kimberly. Oh, there's a question, hold on. From Linda.
Do you have it there, Chuck?
Yeah, so Linda asks, at Douglas Realty, do we need to do anything to continue CE virtual classes? I'm going to say no, and then Kathleen or somebody's going to correct me if I'm wrong, but I think when you get the class approved for CE by the commission, that it carries with it the approval to do that in a virtual or hybrid format. Kathleen's nodding her head. I love when she nods her head after I speak, as opposed to
My understanding correct. Yes, yes, that is my understanding.
opposed to her other reaction.
I'll try to keep that under control.
Trust me, I know when I've said something wrong. So hopefully that answered that. There's one more in the chat. Kelly, thank you for being proactive. Thank you. Yeah, we appreciate your feedback. Thank you, Kelly.
And then Chuck, there was a question about whether or not the conference agenda was actually up on the website at this point.
Oh,
I'll actually ask
Adrian,
that
I
question.
think it is.
I think it is.
To
Yeah.
answer that, there is an updated conference agenda that should be posted by end of day tomorrow. There's a rough agenda that's up there now, but the agenda tomorrow will include our speakers and our session titles.
Great. Outstanding. Thank you. Yeah, please come. It's going to be great.
All right, thank you, Chuck. That was great. Lots of information. And as you can tell, everyone who's participating today, there's been a lot going on this year, even despite the pandemic and everything that everyone's experienced. So it's been busy and we're not done yet. So our next speaker is Bill Costelli. And as many of you know, Bill, he heads up our government affairs department. And Bill has lobbied on behalf of Realtors for over 25 years, which is really amazing. And we're so fortunate to have Bill and his expertise with us at Maryland Realtors. So at this point, I will turn it over to Bill. His camera is not on. Let's see. Are we having a...
He may be setting up his slides.
Oh, got it. Okay.
I don't know.
Okay, give him just 1 second there. And actually, Chuck, you told me to mention the financial wellness, the actual seminar, the all-day summit,
Yes.
and I completely forgot to mention that earlier. So September 8th in Annapolis at the Westin, the 3 webinars that were the financial wellness series that we've done, there's actually an all-day summit that will be happening on September 8th that you can register for in Annapolis at the Westin Hotel, and it will start in the morning with a breakfast. We'll have some keynote speakers. There'll be some breakout sessions, and it's going to be geared for new agents as well as seasoned agents and pretty much anybody in between, talking about your financial future. So it proves to be a real fun day, and I think there'll be a lot of great information, and there'll be lunch provided and an afternoon speaker, and it'll be a good day. So check that out also, and get your registration in for that as well. And Bill is on, so I will turn it over to Bill.
Thanks, Dee Dee. Sorry about that. Our Wi-Fi was having a couple issues. I was going to talk a little bit about a couple of state bills that passed this year that I think everybody should be aware of. I'm going to talk a little bit about a federal bill that's garnered a lot of interest among the members on independent contractors, what the status of that is. We know there's some legislation that went through the House of Representatives, but the Department of Labor is also looking at independent contractor status as well. And Maryland actually took a look at this back in 2009. So I'll remind everybody a little bit about what that history is as well, and then talk a little bit about some of the other stuff that the Real Estate Commission has been handling. Now, as you can see on the corners of our screen, one of them is called Open Doors. And we initiated this year a campaign that was a consumer-focused campaign. We also reached out to our members to talk to them about Open Doors. And what our Open Doors campaign is a consumer-focused campaign. We targeted about 240,000 Maryland voters, and just talk to them about housing supply issues. You all see it in your businesses. We are at an incredibly low amount of inventory throughout the state, and it's impacting everything from home prices to it's so funny when we look at all the bills that get introduced in the legislature this year. There are a lot of bills looking at addressing symptoms of the undersupply of housing. So there are bills looking at trying to restrict tenant screening report histories why? Because there's a lot of tenants trying to apply for housing, and there's a lot of competition for the affordable rental units they're trying to apply. So, but a lot of times the legislatures, local and state governments are looking at some of the symptoms of the undersupply without looking at the supply issue and the impact it has on housing opportunity. So that's really what this campaign is doing. We're trying to show them that, the 50-year lows that we have in some of the housing supply are impacting everything from prices to inventory, and really having a harmful impact on housing opportunities for all Marylanders. So that campaign we really focused on a couple of issues this year. I'm going to talk a little bit about them, and I'm going to actually share my screen as well on a couple of the slides here. So the first issue I'm going to deal with was the Maryland Homebuyer Savings Account legislation. And that legislation is really focused on trying to open up opportunities for Maryland homebuyers who are struggling with closing costs and really the cash requirements that are required for housing. So that legislation right now it passed this year. We had also introduced this bill back in 2018. We were able to pass it through the Senate, but we weren't able to get it through the House. And so the bill this year is focused on, it was similar to the bill that passed in 2018 with some key differences that I'll talk about in a minute. What the bill does do is it establishes a tax-free savings account for Maryland taxes only. There is federal legislation that would also establish tax-free accounts, savings accounts as well for the federal taxes as well, although National Association of Realtors does not think that bill is probably going to advance this year or anytime soon. But this bill will impact for state taxes. You can save up to $50,000 per account over a 10-year period. That's $5,000 a year that you can put into an account tax-free, again, against state taxes. And all the earnings on that account are going to be tax-free as well, up to $50,000 in that account. Now, the legislation itself is really focused on self-designated accounts. So it's really going to be up to you with your with whatever lending institution you have to designate whatever account that you have your money in, and you will do that designation during tax time. So the lender's going to give you a form that'll allow you to designate it. Now, the account is for first-time Maryland home buyers. So we're really targeting those folks who plan to purchase real estate in Maryland. And a first-time buyer in Maryland is defined under the statute as someone who hasn't owned a property in Maryland in the last 7 years. So it could theoretically be someone who owned a property, over 7 years ago, but if they've owned property within the last 7 years, they would not be deemed a first-time buyer. And then again, as I mentioned, you'd be claiming it on the state tax return. And this really applies to any of your accounts, whether it's a money market fund, savings account, could be checking account, any of the accounts that you have with any of your lending institutions. Again, account holder must be a first-time Maryland home buyer, and it's for single-family residential property. So this is residential property only in terms of getting the tax forgiveness. Now, the account proceeds are for anything that's allowable on the HUD-1. So all of those closing costs and cash requirements that are on the HUD-1 sheet, that's what you would be able to use the proceeds from that account for. Could be transfer taxes, any of the fees that are included on the HUD-1 form. And if you just take a look at that disbursement list on the settlement statement, that'll give you a very good idea of how these accounts can be used to lower the closing costs. Now, the financial institution is ultimately going to provide account holders with information about housing counseling, homebuyer education. They're required to do that by the state. We're actually waiting for the Department of Housing and Community Development to develop some of those brochures. And then they are also going to be charged with providing those kind of tax statements that you would use when you file your state taxes at the end of the year. Another bill that we really focused on this year was called the Appraisal Gap Bill, and this also included a study bill. So one of the things that we were interested in, and many of you may have seen this, there was a study that was conducted by some Stanford University professors that was taking a look at appraisals in particular, and whether there were differences in how homes were appraised depending on the color of a person's skin. And what they did find was that there were, in fact, some differences. And they found that there were differences all throughout the country. So one of the study aspects of this bill is to study that issue and whether there are differences in Maryland. And I'll get into a little bit more about what that study does. But the bill also creates a grant program. And this grant program is effectively it's called the Appraisal Gap Program. And what it's designed to do is provide grant funding for the difference between whatever your eligible construction costs were for renovating a property or building a property and what that contract sales price is. So if your construction costs or your renovation costs exceed the sales price that you can get on that property, then you would be able to use this funding to help close that gap as a way to encourage investors to get out there, renovate some of these blighted properties and neighborhoods that we see throughout Maryland. And we know that one of the reasons why we have a lot of blight is because it's difficult. It's difficult for individuals, and it's difficult for even Maryland businesses who are going to buy multiple parcels to put together enough money or to recover enough money in the sales of those parcels to make up for whatever they put in terms of renovation of those properties or constructing those properties. So the legislation moving forward is going to take a look at trying to create this grant program. I would say it's going to take a little while for the Department of Housing and Community Development to put together the criteria and how people are going to apply for it. Although that bill passed and it is theoretically law today because it took effect in July. Now, qualified projects can't exceed $500,000. It's got to be for residentially, either new construction or formerly vacant residential structure that's going to be substantially rehabilitated. So as long as you're focused on that rehabilitation or residential, and it's got to be in a low income census tract area as designated by HUD and a sustainable community, which is designated by the Maryland State Department of Housing Community Development. So these are all low income census tract areas. And again, it's really designed at those blighted properties and providing a financial incentive for investors who just can't realize in the sales price what they're putting into those properties. Now, the bill specifies that although they don't call it a grant, it is actually a grant because the bill specifies that what financial assistance is not. It doesn't really, tell to the Department of Housing and Community Development that financial assistance has to be a grant, but it makes it very clear that the financial assistance the department provides cannot be a loan or anything that is effectively going to be a lien on the property moving forward, a debt or a lien on the property moving forward. So, the likelihood is that this is going to be some kind of grant program. There are some limitations to it. You can't exceed the lesser of 35% of the total cost of the eligible construction or 80% of the national median sales price that you can receive, that you can get in that particular area. Now, as I mentioned earlier, DHCD is also going to be doing a study. That study is going to take a look at whether there's been discrimination on the basis of race and community investments, real estate financing, real estate appraisals. That report is going to be due by December of this year. So prior to the 2022 session starting, the hope is that the legislature will receive a report and point out, anything that they uncover and that the legislature can address either through some of their appropriations or through changes in the law. So we'll move on to the federal bill. We've gotten a lot of questions about the PRO Act from members and brokers. And just to recap what happened back in May, the House of Representatives passed HR 842. That is the bill is referred to as the PRO Act, but it is a bill that really is seeking to create what's called the ABC test for independent contractors. So there was a lot of concern in the industry about, does that mean that, everybody who is an independent contractor today is going to end up being classified as an employee in the future under the ABC test? That bill, although it passed the House, is now in the Senate. It is not expected to receive a vote in the Senate. In fact, there's not enough Senate support for it to move forward. But the Department of Labor is also looking at regulations. They had also had a regulation that would have implemented a kind of ABC test as well. That test and that rule got pulled back by the Department of Labor. National Association of Realtors has been in communication with the Department of Labor about that. And, it's important to our industry. 87% of our 1.5 million members across the country actually operate as independent contractors today. So there's a lot of interest in it. The only thing I can tell you right now is that it is not expected that legislation is going to move forward. And it is unclear what's going to happen with the Department of Labor regulation right now. Now, under the ABC test, there is one element of that test that talks about whether you are part of a recognized independent trade or profession. And so, but it does create some clarity issues in terms of whether a real estate professional would be deemed an employee or still an independent contractor under the bill. I will tell you that Maryland, back in 2009, had a bill called the Workplace Fraud Act. And that bill actually took the ABC test that you've heard about and applied it to two very specific industries in Maryland. At the time, they were talking about applying it to a bunch of different industries, but it ended up being narrowed to construction services as well as landscaping services. So although Maryland does have an element of the ABC Act in law, it really applies very specifically to two industries, does not apply to real estate. And real estate and insurance and a bunch of other professions currently follow a more flexible rule in terms of whether the employer exercises, very direct and very specific control over their means and method of doing their job. So right now, I would say it's status quo. We expect that to be status quo for some time, but there is a lot of activity. So just, keep in touch with the National Association of Realtors and the Maryland Realtors news updates about, whether the Department of Labor rule starts to move forward and whether as that federal legislation gets debated. And we do expect that the Senate is going to, and they have had hearings on it. We expect there's going to be additional discussion about it.
Well, we have some questions. I want to make sure we leave time for Kathleen and Colette.
Yeah.
And there are some questions. I mean, you see, and in the chat as well. Do you see those?
Yes. Does first-time Maryland home buyer mean never owned residential owner-occupied investment property in the past 7 years? So what it means is that you have not owned a residential property in the last 7 years. The bill doesn't talk about the status of whether it's residential or commercial property. So I suppose there is a little bit of a question in terms of if you owned like a business property, whether that would disqualify you. But the intent of the bill is ownership of residential real estate. So that's why the context of the bill has been residential. So I would say it's an open question if it's been like investment property that you've had and whether that would disqualify you. And then does the appraisal gap law allow profit for the investor? Yeah, and that's really what the whole point of it is to try to provide a means of profit for the investor. I will tell you in terms of the construction costs that the appraisal gap bill allows, it's not the typical cost that you would have in construction. I mean, it's all of the doors, the labor, all of the stuff that you would normally put into when you're constructing a building or renovating a property. It also includes acquisition costs, tool rental. So they try to make it fairly broad so that an investor would have some interest in actually investing in a property so that they could make some money on it moving forward. Last thing I'm going to mention, I won't talk about virtual continuing education. Chuck covered that. You may have seen pay at the table issues with the Real Estate Commission. The Real Estate Commission actually redefined kind of what that pay at the table rule, and it really wasn't even an official rule or regulation before the commission, but there had been understanding and guidance with the Real Estate Commission that for any of the brokerages that wanted to establish a pay at the table arrangement with their agents so that those agents could be paid their commission or their compensation at that settlement table, they would be able to do that. So the new commission received some questions about that. The new counsel on the commission reviewed the law, felt that the current statute didn't support the previous interpretation that another counsel had with the Real Estate Commission. And so they issued guidance back in the spring saying that those pay at the table arrangements do not comply with the current statute. Our public policy committee took a look at that. They were kind of neutral on it, but the executive committee really has directed staff to try to draft legislation for the 2022 session to go back to the status quo that had been in effect for probably 30 years. And that would allow those brokers that want to have those kind of commission arrangements able to pursue them. Those brokers that don't wouldn't have to. I'm going to end my sharing of the screen right now.
Yeah, and Bill, there's actually two other questions that were in the chat, not in the Q&A, and I'll take them together because I think you're going to answer together. The first was, does the 50,000 cap include the interest that would be earned on that account? And then are we working on a gap disclosure addendum?
First question, yes, it would include 50,000. So theoretically, at whatever point you reach 50,000, so if you're doing the $5,000 a year, you know, it wouldn't leave much of your investment earnings on that account. So it is going to be capped at 50,000 over that 10-year period. And then you have 15 years actually to use the money in the account. And then as far as a gap addendum, I guess I'll leave that to Kathleen or Colette.
Yep, sounds good. All right, thanks so much, Bill. I appreciate that. And if I could, with the participants, remind everyone, you can't raise your hand because you're in viewing mode. We're the panelists. So you're watching, and it's probably easier for us to monitor if you type in the section that says Q&A for the questions, as opposed to the actual questions coming through the chat, because that is two different sections. So if I could just ask for the questions to come through the Q&A, and just know that we can't acknowledge you if you're raising your hand, but please feel free to put the questions in the Q&A. So, all right, thanks so much, Bill. Next speaker is Colette Massengale. And she started a new role with the association as our Director of Professional Development and Member Engagement, which is very exciting. However, because she was contract committee staffer for most of the year, she will be discussing our forthcoming changes to Maryland's statewide real estate contract. Prior to joining the Realtors, Colette worked for several firms, law firms in Washington, D.C., and she also served as a law clerk for a D.C. Superior Court judge. So I'll turn it over to Colette.
Thank you, Dee Dee. So I'm going to go ahead and share my screen. And before I get into the changes that you'll see, can everybody see my screen? Okay. Can see it, Dee Dee? Good. Okay. So let me just answer that question. Yes, the Statewide Forms Committee is working on an appraisal gap addendum. We did receive, or I should say the Statewide Forms Committee did receive permission from the Executive Committee to prepare the form. We're working diligently on that, and actually in another form. And assuming it goes through the process, it will be part of the rollout of new and revised forms that you'll see in October. So that is in process. Kathleen, you can chime in if you have anything to add to that.
I think just the phrase appraisal gap, I think it's being used in two different contexts. What Bill was talking about, it's sort of the like a different appraisal based on the race of the homeowner. You know, properties that are owned by a certain race would be disproportionately lower than the same property if it was owned by somebody of a different race. So then Bill's talking about it in a different context. We're talking about it for the statewide forms is talking about it more in the context of the current market, where the buyers are willing to offer more than the appraisal, and what happens if there's a gap in the difference between the appraised value and what they're willing to pay. So two different contexts, but we're using the same words. So sorry if that was confusing.
Thank you. Thank you for the clarification, Kathleen. All right, so let me just talk a little bit about what you'll see in October. But before I get that, I did want to just point out that the residential contract of sale has been updated. The current version of the form is dated July 1, 2021. So that is the contract that hopefully everybody is using. We had to update the form pursuant to a change in the law. So the current version of the form has a new paragraph 55. It's titled Homestead Property Tax Credit Notice. It's that notice was mandated, gives notice to the buyer that they may be eligible for the homestead property tax credit. So there it is. You see it there. The language is in bold. There's a link to additional information about the homestead tax credit. So again, everybody should be using the residential contract of sale dated July 2021. All right. So now let me just talk about some of the changes. So that July version of the contract does not include these additional changes that I'm about to talk about. They will roll out in the October version. So, but I just wanted to just make sure that people are using that current version of the form. So the first change that I'll talk about is going to appear on page 1. It's the payment terms provision. And as you all know, practically speaking, in a lot of instances, the buyer submits their offer and they don't always submit the earnest money deposit at the time of the offer, even though the way the contract is currently worded, if there's going to be an initial deposit or a first deposit, it's to be delivered at the time of the offer. You all know that that doesn't always happen. And technically speaking, if the buyer does not submit the earnest money deposit at the time of the offer, if that's what the parties have agreed to, then that's a breach of the contract. So this revision gives some flexibility. So if you'll see there, the highlighted version, the buyer has delivered or will deliver within a certain amount of time within a date of contract acceptance, the initial deposit, the amount of it. So that again gives some flexibility there and just accounts for the good many circumstances where the earnest money deposit, the initial earnest money deposit is not submitted at the time of the offer. The only other change there, you see the highlighted language there, that's really just a technical change. That language is already in the contract in paragraph 7C. If not a Maryland licensed real estate broker, the parties shall execute. And basically, if the buyer and seller agree that the earnest money deposit is going to be held by a title company, then the buyer and seller are obligated, based on prior changes to law, to execute an escrow agreement. So this is just bolding that language. So no real substantive change there, but the real substance is to paragraph 7A there. There is also a change to paragraph 24, which is the settlement cost provision. The Statewide Forms Committee, there's a lot of discussion about circumstances where the seller does not show up at settlement, and there may be costs associated with that. So this is really just a notice to alert the seller that if they're not able to attend settlement, they should reach out to the title company to determine if there are any charges that may apply. So just a notice to the seller in that scenario. So that's the change there to the settlement cost paragraph 24. The only other change is to paragraph 60. We talked about the homestead property tax credit notice, paragraph 60. If a mortgage or settlement company requires wet signatures, all parties agree to promptly re-sign the documents so that there's no holdup of settlement and everybody gets to closing and moves on. So again, these are the changes that you'll see to the contract, and any that apply to the unimproved land contract, those will be made as well. All right, so that's that. Let me go on to talk a little bit about some of the changes to the addenda. And I'll say this change here to the property inspections addendum, very kind of minor there. You'll see, but since you'll see property inspections addendum with the 10/21 date, I just want to alert you. A lot of times the committee, if there's any tweaks that need to be made, will make them. The change here is just to simply align paragraph 4C with paragraph 4A when it comes to the credit. So in 4A, what it says, if within the time period specified buyer fails to have the inspection performed, or if they fail to submit the report along with the separate written statement, and what corrective action and or credit. So it says and or credit. So we're mirroring that and or credit language in paragraph 4C. So you'll see that from time to time, any sort of technical changes, you'll see those made as well. So just wanted to point that out because you will see the 1021 version of the property inspections addendum. But that's the only change to the property inspections addendum.
Excuse me, Colette, could you zoom in on those changes or just each document?
Oh, sure.
As you go through it, just zoom in a little bit. Yeah.
Yep. So here is just a very small sort of, update there. That's all the changes there that you see to paragraph 4C. And that and or language mirrors the and or language in paragraph 4A. All right. All right. So let us go on and talk about the water yield test addendum. Let me make that a little bit larger. All right, so here, this is just an opportunity for the buyer and seller to agree on the type of test that's going to be conducted. It'd be a 1-hour test, 3-hour test, and also, depending on the length of time and what's involved, the seller will be prepared, know what to expect. So again, just a tweaking of the form to allow the parties to distinguish the type of test that they are going to that's going to be conducted. So that's a change to the water yield test addendum. Let me go on to the on-site sewage disposal system inspection test addendum and make that large. So as of or after July 1 of 2022, the only individuals that can inspect an on-site sewage disposal system will be an individual who has a license issued by MDE. So this notice is put in there to alert the parties of that fact. That's the only change to the on-site sewage disposal system inspection and test addendum. So I just want to make sure that buyer and seller are aware that these individuals have to be licensed after July 1 of 2022. All right. Go on to changes to the brokerage forms now. So those are the changes to the contract. And changes to the addenda to the contract. Now I'll talk a little bit about changes to the brokerage forms. There's really only one major change to the exclusive right to sell and the exclusive buyer, and I'll make that highlighted language a little bit bigger so you can see it. There's been a lot of discussion, not just in the statewide forms committee, but in a lot of the other committees, and you all know about the changes that were made to the NAR Code of Ethics under Article 10, pertaining to fair housing. So this is not a new provision. This is paragraph 11. This is a revision to the fair housing provision, alerting the parties that there are fair housing requirements under federal, state, and local law. You all know that. There are additional protected classes in a lot of jurisdictions in Maryland. More so than the federal, the 7 federal that exist. There's the additional state. And then of course, you all have seen that Excel sheet and the different ways that we have discussed those protected classes under local law. So we make that apparent or make that clear to the parties. And it also, I assume or believe, because we talked about this in various contexts, the guidance regarding love letters. So there's the discussion about ensuring that the seller complies with it. Actually, this language was tweaked to say that the seller agrees to comply with federal, state, and local fair housing laws. We've had a couple of cases in Maryland. Kathleen, maybe we'll talk a little bit about that, dealing with situations where buyers were discriminated against, and in the negotiating process, where the negotiations were going very well, and then the written offer comes in, and the seller sees the buyer's name and decides that they don't want to proceed with the transaction. So a lot of discussion about that, various committees. We tweaked the fair housing provision. There's also been a lot of discussion about love letters. We've talked about that in some of our legal hotline sessions. We've talked about in CE. So this change here basically says, and this follows the guidance from the National Association of Realtors, as well as the guidance that Maryland Realtors has provided when it comes to love letters. The concern with love letters, as we've pointed out in the past, is that there is the potential for there to be fair housing violation if that love letter references something about a protected class and the seller makes their decision to accept the offer based on that discussion in the letter pertaining to a protected class. So it opens the door to potential violations of fair housing. And so NAR's guidance has been very clear in terms of, not writing them and not presenting them. So this language says, these love letters can expose the seller and the broker to possible fair housing violations. And so to avoid that potential for there to be a violation of fair housing, then the seller instructs and directs the broker to remove from the offer any communications, a counteroffer, any letters, photographs, or videos that accompany the offer, counteroffer, any other communications. So that's the change there to the fair housing provision. The same or similar language has been included in the exclusive buyer-tenant representation agreement. So that change, that's paragraph 5 there, and paragraph 11 of the exclusive right to sell. And then I just kind of included this love letter, liability letter. This is the guidance that NAR has put out. I hopefully you've seen this. Really, really key to educate your clients about fair housing laws and the pitfalls of buyer love letters. Inform them that you won't deliver them, that you they won't be, accepted as part of the MLS listing. Remind your clients that their decision to accept or reject an offer should really be based on the objective criteria. Of course, if your client insists on drafting a letter, and that, again, with this new language that we've incorporated, hopefully minimizes the chances of that happening. So that's the change to the brokerage forms, the addenda. This is the Lockbox addendum to the exclusive right to sell residential brokerage agreement. So let me just make that a little bit bigger. We have a new paragraph 4 here. And this is really to cover those situations where the seller elects not to use a lockbox and it decides or elects to use like home security system or some other means of allowing access to the property. If they elect to do that, then they're not going to, if something happens, there's some damage to the property or loss of some sort, that they won't hold and can't hold the broker or agent liable. So that's a protection there for the broker and agents in those situations. That's new paragraph 4 of the Lockbox addendum. And then there's one new form at this moment that has been approved and gone through the process. And that, of course, is dealing with solar panels. Over the last couple of years, the Statewide Forms Committee has discussed solar panels. There's talked about some of the issues surrounding them in terms of getting the solar panel documents to the buyer. And so this solar panel addendum to the exclusive right to sell residential brokerage agreement really kind of focuses on disclosure. So this information is readily available to the buyer. So I think it's pretty straightforward. There's the acknowledgement that there is, in fact, a solar panel system on the property. Talks about or allows or provides space for the seller to disclose who the solar panel manufacturer is, requires the seller to disclose whether they own or don't own the panels, who it defines the term lessor lien holder, explains what the financing is it subject to a lease? Is it subject to a power purchase agreement? Is it an unpaid loan? Whatever the case may be, discloses the information for this financing party. If there are any fees involved, what are those fees? Those are disclosed. Any transfer fees. The seller agrees to provide any copies of any documentation related to the solar panels to the buyer. And then, of course, if there is any warranty transfer, that would be disclosed, and the seller acknowledges whether or not that exists and how that would work. So that's the solar panel addendum to the exclusive right to sell residential brokerage agreement. And that is so far. There may be, again, the appraisal gap addendum that Kathleen mentioned, and that may be part of the library in October, depending on whether it gets through the process. So that's all I have as far as updates to the forms. And I will say too, and I don't know if Bill, did you mention this, the zones of dewatering influence? The legal department, here's my understanding, and Kathleen, you can correct me if I'm wrong, with regard to the notice to buyers being in the contract in those areas where there is a zone of dewatering influence. I believe the approach that we're going to take is to prepare this language and then offer it up to those boards where these zones of dewatering influence are. But basically, zones of dewatering influence make the property, or means that the property is susceptible to sinkholes. And in these areas, owners are eligible for certain remedies, and buyers may be able to add additional insurance. And so that language, again, will likely be in the form of just a model language that we share with those areas where this is an issue. So that's all I have. Any questions, Dee Dee, in the chat?
Yeah, we have questions, Colette. We should probably go through those. What's the first one? I guess Tina Hyatt, I apologize. Is it possible for Maryland Realtors to notify managers and brokers of contract changes via email? I guess the July 1 change wasn't sent out to us, and that we apologize. We do have a distribution list for people who want to be updated about the forms. So that I guess send an email to me and we can add you to the distribution list and make sure that you receive an update or notification of the forms that are changed.
Yeah, how we usually do it, we did this update the same way we do the other ones. We send it out to the vendors, we post it on the website, we send it out to the AEs, and as Kathleen mentioned, we send it out to forms educators and also the forms contacts, and anybody who is getting the forms in advance. We always, for educational purposes usually, or for some of those brokers who have their own sort of forms platform, we ask them to sign the Maryland Realtors Forms Licensing Agreement.
All right, there's another question. It says no confessed judgment needed if buyer says he or she will deliver the EMD in a certain amount of time within the contract. Personal check still acceptable form of deposit to the contract. So I guess, yes, a personal check is still acceptable.
Yeah.
I'm not sure what the confessed judgment.
We don't have that. It's okay. We don't have confessed judgments in our contract.
Right. So, but that's, I guess, the real question, is it acceptable to say that the EMD will be delivered within a certain time frame? That's exactly what the change contemplates.
Right.
Sort of they'll deliver it within a certain time frame. Or they can even structure it as an initial deposit and an additional deposit. So there's a little more flexibility now than there was previously.
Right.
So that is a good question. There's another one. This change means that we as brokers, as agents, should be removing love letter type content from our offers received prior to presenting them to our clients. Yes, I think is the answer to that. It's I guess the best way to do this would be to treat this sort of as an educational opportunity. I think, Colette, chime in if you have anything else to add, from the buyer side and from the seller side, right? If you're working with a buyer, they're going to sign their buyer agency agreement. You could go through that paragraph, explain to them what how the fair housing laws apply. They're going to abide by them. And this means they shouldn't do a love letter. I mean, I know that some people are doing them, but they really shouldn't. If they do prepare a love letter, you as the buyer's agent, you're going to remove it and you're not going to present that to the listing agent. And the same thing on the listing side, if the listing agent receives a love letter, a love photograph, a love video, the listing agent is going to remove that and not present it to the seller. So that's a good question, Allison. That's exactly what the intent was. To the client authorizes the agent to remove it and not to present it. So that's a good question.
And am I right, Kathleen? Isn't there a state now that has passed some legislation pertaining to love letters? Is that right?
Oregon.
Washington State, maybe?
Oregon.
Yeah. Oregon.
Yeah. So their law says it's illegal. You can't present letters, period. So they didn't do it in the contract or the listing agreement.
I personally wouldn't mind if we did that here, frankly.
All right. Take a
Take
note
the
for the Public
pressure off.
Policy Committee.
Well, no, I'm just saying.
Yeah.
I'd like to take one if I could real quick. Jeffrey Lewis, it's a very good question about the way we're organized basically, and his kind of question or observation, or actually it's a question. Why don't we switch to a statewide form so that people don't have to be aware of a lot of local changes or addenda or disclosures, et cetera. And I can tell you that if you think our contract is unwieldy now. If we incorporated into one contract every local disclosure, it would be at least twice the size it is today. From Carroll County's right to farm laws to Southern Maryland's disclosures, every county has specific disclosures that only apply in that county.
Airport. Airport disclosures sometimes.
Yeah, for example, like in Anne Arundel, yeah. And so we have stayed with this model. And I think the actual answer is sort of in your question, Jeffrey, when you say agents not using proper local addenda because they're not aware, that's a problem. And I think the solution, rather than double or more the size of the contract, is to train agents if they're working within, if their office is located in Anne Arundel County, of course, they can do a deal on the Eastern Shore. They can do a deal in Frederick County. They can do a deal, as long as they're aware in Garrett County, or sell a condo in Ocean City. But they need to be aware of the local laws, and that's an element of competence. Our code of ethics requires that if you are doing work of any kind outside the scope of your, current employment or zone of comfort, that you need to educate yourself about what the local requirements are. And so that's I got to be real honest with you, that's on you guys. You're the brokers and managers. The agents that are affiliated with your companies, they need to be reminded by you. You can help us in this effort by saying to your agents, if you are coming from Anne Arundel or Baltimore or whatever, and you're working outside of this area, if you're going to Howard County, if you're going anywhere else, Carroll County, you need to educate yourself as to what's required to write a contract in those local jurisdictions.
Yes, and I would, just to add to that, we update the contract every year, just about. So at the very least, you want to take a contracts class, or your brokers, have a contracts roundtable. I know some of the brokerage companies, Kathleen and I, and some of the other attorneys have gone to sales meetings where they focus on the contract and the updates and changes. But at the very least, you want to make sure that you're, check in with the library, the website, hot sheet, to see what the updates to the contract. It's always changing, on the state level, and I'm sure on the local level as well, as far as disclosures and notices and various addenda and things like that. Any other questions, Kathleen or Dee Dee?
I think
There's actually quite a few.
the water yield addendum, the option for different tests might lead to an agent giving that advice to a client in an effort to get docs signed more quickly. If a buyer or seller isn't familiar with the water yield test and doesn't know which to choose, that advice should come from a licensed water testing person. Correct. That's kind of consistent with a lot of the forms. You can explain to the seller what the options are. The seller is always going to make the choice. The agent shouldn't be picking a 1 hour because it's quicker. That should never be happening with any form or any test. You should explain to your client what the options are. If they have additional questions, who is this? Debbie asked this. Your point is exactly correct. They could speak with a licensed, or should speak with a licensed water testing person if they have more nuanced questions or more detailed questions. And you always want that to be the client's decision. The agent should not be making a decision for the client, particularly just on the basis of speed or expediency. You really want to explain the situation to your client, and your client's going to make the decision. That really is with a lot of these options where the client can make a choice. That's how it should always be done. And the water yield addendum would be the same, consistent with the other guidance you would give.
Right.
Kathleen, why don't you give your presentation? People are starting to drop off, so let's make sure we get through everybody's segments, and then we'll stay here as long as people are hanging in with us to answer the remaining questions. But I want to make sure everybody has their presentations out in front of everybody. And again, we'll stay as long as it takes. As long as people are on and asking questions and interacting with us, we'll stay on. We don't have any time limit for us to sign off. So as long as you all want to stay, we'll answer questions.
Okay.
Yep. I'll give you your, I think everybody knows Kathleen, but I'm going to give her the introduction that she deserves.
Oh.
Thank you, Colette, for all your information, for sure. And the nice thing about not having the hard stop at a venue where we'd all be in a ballroom right now is we control our own webinars. So Chuck is right. We can continue to answer questions as need be. Not all night, but for a reasonable amount of time following Kathleen's presentation. Oh, so our final speaker is Kathleen Dartez, and she heads our legal department. Prior to working at the Maryland Realtors, Kathleen served as general counsel for a regional real estate brokerage firm. She was the managing title attorney for a title company, and she worked for a foreclosure company as well. So if it seems like Kathleen has a lot of knowledge, there's no doubt that she does have a lot of knowledge in this department. And because of that significant experience in our industry, Kathleen's not only an expert on real estate laws governing our companies, but understands profoundly the operation of our companies and the industry. Kathleen?
Yeah, thank you, Dee Dee. That's, I guess, one advantage of getting older. You have more experience under your belt. So we're going to talk about some legal hot topics. There's a little bit of overlap or segue, I guess, between what Colette was talking about and even what Bill had talked about. A lot of times why, we update the forms is we're hearing questions on the legal hotline and we're aware that there's an issue. We'll bring that to the statewide forms committee. And that's really what we're all about. We all collaborate within departments. If we become aware of an issue, we can bring it to Bill or Susan. They would bring it to the public policy committee. So some of the things that are in this part of the presentation, we've touched on already. Colette has done the forms update. Some of these things, honestly, as Dee Dee said, we're talking a lot about operations and risk management, key concepts for brokers. Some of these topics up here are really back to basics, but I look, before I teach ethics, I look at the Maryland Real Estate Commission, their website. I look at disciplinary actions, what agents are being disciplined for, and a lot of them are basics. There still are back to basics. There still are people being disciplined because they didn't collect the EMD, the check bounce, and they didn't tell the other party. So a lot of this seems repetitive and really sort of basic, and it is, but you're the broker, you're the supervisor, you're the manager. You just need to make sure that everyone in your office is following the procedures and everyone's aware of what the procedures are. So this is basically what I'm going to cover. We do want to allow time to get through the questions, so I'll go through this, and again, feel free to ask questions, type them in as we go through it, and we'll address them afterwards if there's any questions remaining. So these are the, I think Colette had gone through the forms update already. That is everything that was on. Yes, even the one for the sinkhole addendum, that's Baltimore County, Carroll County, Frederick County, and Washington counties. We're going to put some suggested verbiage to the locals. And again, the concept was it only affects 4 counties. So that's why it was not going to be included in the state contract. Instead, it's going to be done by those 4 jurisdictions in their local forms. Again, sort of said the basics here: earnest money deposits and contracts release. You may or may not be surprised how many questions we get on the legal hotline about these. Initial and additional deposit. Colette just went through the changes that are going to be made there. But just even with the contract, the way it's written now, remember, first of all, it's not legally required that there be a deposit. I know Chuck would be ecstatic if we got rid of that, if it was sort of a practice where people didn't make EMDs, but I'm not sure that we're there yet. Fingers crossed, Chuck. But the way the contract is set up now, it does contemplate an initial deposit and an additional deposit. And this may have been more of an issue with COVID, but you could specify that there is an initial deposit of 0 and an additional deposit of whatever you want, $1,000, $5,000, whatever it is. And then there was a time frame in there as well, within 5 days of contract acceptance, within 3 days of contract acceptance. So we get asked questions about that a lot. The bottom line is, if you say that you are the brokerage and you are holding a $3,000 deposit, if it's on there as the initial deposit, you need to have that in hand. If you do not have that in hand, you should put 0 as your initial deposit and then put that amount as your additional deposit that you will have within X number of days. Again, the Real Estate Commission, this is pretty much a 0 tolerance kind of area. If the contract says that your brokerage is holding the EMD, you better be holding the EMD. And the other issue, I guess, where a decent number of people, maybe an indecent number of people are disciplined by the real estate commission if the check is returned for insufficient funds, if the wire is dishonored. If you are the broker who is holding the EMD, you need to do something about that. You need to notify the other party, let them know that the check bounced or the wire was dishonored. There was one agent who was disciplined, I think it was a year or so ago. The check was returned by the bank for insufficient funds. I think the buyer was transferring money from, I don't know, a Fidelity or T Rowe account, transferring it into their checking account. They thought the check would clear. I guess it took longer for that money to come from the outside account into their checking account. So the check did not clear. And I guess whoever processed the check at the brokerage didn't notify the seller, didn't notify the listing agent. I'm not even sure that the buyer's agent knew, but essentially I think they just put it through again and hope that it would be honored or go through validly the second time. And that agent was disciplined, and the real estate commission said they should have notified the seller and or listing agent immediately. They shouldn't have crossed their fingers and try it a second time, or cross their fingers and say third time's the charm. So you all as brokers and office managers, you understand that that's your responsibility, but you also operations, you need to make sure that whoever's processing your checks at your front desk, your accounting people, whoever it is, that they know if a check is dishonored, if the check is, wire's dishonored, the check doesn't go through, they need to escalate that immediately. They need to let the agent know, need to let you know, need to let the seller know, the party on the other side as well. And licensees who are not doing that are being disciplined by the real estate commission. Side note, I'm going to say that the licensee, the agent tends to be disciplined. I'm not sure why the brokers tend to not be disciplined. I know I'm in front of a broker manager group, so I'm not going to say any more, but we do have broker supervision, and the money should be going into the broker's account. So you should be getting the notice if the money is not, the check doesn't go through or the wire's returned. So make sure that you're aware of that. Make sure your staff is aware of that. Make sure your policies are clear so everyone knows that they need to escalate that immediately and not just keep their fingers crossed and hope that it works out. And we do get a surprising number of calls on the legal hotline where the transaction falls apart 3 weeks afterwards, or the buyer has some financing issues or whatever. The seller thinks they're going to get the EMD, and only at that point do they learn that the buyer's broker never collected the EMD, or the check bounced, or they never received it. So you definitely don't want that to happen. If there's going to be a problem, God forbid, find out about it up front, right? Deal with it up front rather than keeping the seller's property off the market for 3 weeks and then finding out about the problem. Brokerage versus the title company. Again, we talked about this a little bit, I think previously, about the escrow agreement. The bottom line, again, from a practice perspective, I would say, and my recommendation would be it doesn't matter if a brokerage is holding the EMD or if a title company is. I would suggest that the listing agent verify regardless. The easiest thing, or the best thing I think about that escrow agreement that the title companies have to utilize, they don't have to utilize our form, but there does have to be a written escrow agreement if someone other than a broker is holding the EMD. The Maryland Realtors form, it does have basically a receipt on the last page where the title company is going to sign that, and they're going to acknowledge that they've received the EMD in the amount of whatever it is. Again, the practice pointer, your agents, make sure if they're sending that, if the title company is holding that money, make sure they get that page back. Make sure they verify that the title company actually has the money. We've received calls on the legal hotline. The buyer was supposed to send the check to the title company, and they did not. And there's supposed to be a written escrow agreement. And if anyone had followed up on the written escrow agreement, they should have realized that the title company did not have, never received the check. Of course, no one bothered to look into it, I guess, or didn't think about it until the transaction fell apart. The seller thinks they're going to get the EMD, and the buyer never gave the check to the title company. The listing agent said, well, I shouldn't have to verify that. The buyer said they were going to do it. Shouldn't the buyer's agent have to verify that? And the buyer's agent said, why should I have to verify that? The buyer said they were going to get the check over to the title company. That's not my responsibility to hold my buyer's hand and get the check over to the title company. So I'm just saying, regardless of which side you're on, the best advice would be to verify whoever is supposed to be holding the EMD, that they are actually holding the EMD. I would say at a minimum, just send an email to that person and have them verify that they have the EMD, they're holding it, the check cleared, whatever you want to say. But I wouldn't just keep my fingers crossed and hope that the buyer delivered the money. That's a bad situation for the buyer's agent to be in. It's a very bad situation for the listing agent to be in if the transaction falls apart and doesn't move forward. Show and tell. There, aren't I clever? Basically, I think if your brokerage is holding the EMD, you should not be surprised if someone is asking you to verify or confirm that you have the money. Like I said, this happens more often than you would realize. Don't be insulted or offended. You don't have to give them a copy of the check or your bank deposit. It could be done just by email. Someone could ask you to confirm that your brokerage is holding the EMD. You could respond truthfully, honestly in an email and verify, yes, that you are holding the EMD. And again, the tell part of that is if the check was dishonored or the check was returned for insufficient funds, the wire is dishonored. Again, you want to notify the other parties, make sure your staff, make sure your assistant, everybody on board who would be involved in that process, make sure they understand the urgency of this and that they need to escalate that immediately. So it's dealt with immediately, you don't find out the day before settlement that the deposit was never made. Mutual versus unilateral release. Again, this is sort of just a contract release provisions. I think for the most part, everyone is clear. There's some situations where one of the parties could terminate unilaterally. The most common one, I think, probably would be condo and HOA documents. The buyer receives them. If the buyer doesn't like whatever's in there, maybe the buyer has a large dog and the condo only allows small dogs. The buyer said, forget it, I'm not going to move in there. The buyer can use the unilateral termination and terminate that. They don't have to explain why or what size of their dog or any of that stuff. They can just terminate. This does come up a lot in the legal hotline. Sometimes a party has the right to terminate, the unilateral right to terminate. Again, just good practice. If your client has the right to use the unilateral termination, unilateral meaning one party, right? The buyer is the only one who needs to sign it, or the seller is the only one who needs to sign it. If you're in a situation where that's the case, that's the cleanest way to terminate the contract. It really is. I would recommend that where it's possible. If not, both parties have to sign, and then it gets a little bit more challenging sometimes. An easy example or question that comes up a lot, this is kind of tied to the last bullet point as well. Let's say if the buyer is unable to settle on the agreed upon settlement date. The party, the buyer's agent asks for an extension of the settlement date. The seller says no. The buyer was supposed to have settled yesterday. They had, till midnight yesterday to settle. They don't settle on time. Today, the seller can send a unilateral termination to the buyer, terminating the contract. The buyer doesn't have to sign it. The buyer doesn't have to smile when they get it. They don't have to like it. That contract is terminated. And then the seller could put the property back on Bright MLS as active, could accept another offer. But that is key that they terminate that contract. There are real estate commission cases where people have been disciplined for not terminating the contract. The contract does not die on its own. There was one broker who lost his license. His license was revoked because he was a listing agent and he told the seller that the old offer, the buyers didn't settle. He said the settlement date had passed and that offer just died on its own. They did not need to worry about it. In that case, they should have worried about it. In that case, they should have sent the unilateral termination to buyer number one and it would have been all resolved, no worries. Instead, buyer number one still wanted to purchase the property, hired a lawyer, filed a lawsuit. There was a huge, big dispute. The sellers had to spend a lot of money on attorney's fees because they had entered into a contract to sell their property to buyer number one. They had also entered into a contract to sell their property to buyer number two. So if everybody walks away with nothing more than this, I would say this is critical. This is really important. There has to be a release or termination of the contract. So basically settle or release. If they don't go to settlement, if they want to get out of it, want to accept another offer, they have to do a release. Of course, they can always extend the settlement date. They're certainly free to do that. I'm not saying they shouldn't, but at some point, if the seller wants to move on, just remember the contract doesn't die on its own, does have to be terminated. All right. Another issue that has been coming up recently, especially with the market being the way it is, the inventory shortage, unauthorized showings, sort of a variety of ways this is taking effect, as just, I guess, as creative as people want to be. There were agents who were sneaking their client in between appointments. Agent number one, this buyer's agent has made an appointment through CSS or through whoever it might be, showing time. Another agent, we heard about this a couple months back, another agent would just show up and kind of just bring their client in. They had not scheduled an appointment, had not made an appointment. They just went in sort of between appointments or would join somebody else when they were showing the property. That is not permissible. You are supposed to show the property in accordance with the seller's directions, with the instructions the seller has provided, which is going to be, consistent with those guidelines from those showing services. And if you don't have an appointment, you're not supposed to be going into the property, period. Another situation that comes up periodically is the agent is not present. There are situations, I think some of the local boards have disciplined agents for this as well. I know the Real Estate Commission has as well. There were a couple years ago, and I think even some more recently. If the buyer's agent is not able to show up at the appointed time, sometimes the buyer agent will give a code to the buyer, and the buyer will go into the property unaccompanied by their agent. That is not permissible. If your agents are doing that, make them stop because they're going to be disciplined by the Real Estate Commission. And there have been people who've been disciplined by the Real Estate Commission. That is not consistent with the seller's instructions. They shouldn't have, people in there if they're not accompanied by an agent. So again, your practice pointer as a broker, as an office manager, figure out what you're going to do. Tell your agents, what do they do if they can't make it? Have another agent from your office help them out and show up, have them reschedule it, whatever they want to do, you can help them work through it. But what they don't do is just tell the buyer to go on in and let yourself in. It's not authorized. It's not ethical. And honestly, there could be some health or safety concerns as well. What if the person has a dog that's not secured? What if there's a person has a gun? They don't know someone's going to show up, or they think there's going to be an agent or something. It's really a risky behavior. Ethically, it's risky. It could affect your license. It could be a fine, and really it could be a health or safety issue as well. So just make sure your agents understand that. And even honestly, even if the property is vacant, they still should have an appointment. The agent should still be with the client, even for vacant properties. These are just some trends that were really tied, I guess, to the current market. Multiple offers, based on the inventory shortage. Presenting offers. This, I think everyone has taken a class in the Code of Ethics. Everyone knows here in Maryland, we do have a regulation requiring that all offers be presented, offers and counteroffers, be presented in full and in writing, unless otherwise provided in the brokerage agreement, right, Colette? Colette was going to jump in there and clarify that for me. But essentially, all offers should be presented to your offers and counteroffers should be presented in writing and in full. And the question that has come up, or a practice that we've heard about in today's market with such a shortage on inventory, it's possible that your seller might be in a great position. They may receive 12 offers, and I'm the listing agent. I want to be super helpful to my seller. I'm going to prepare an Excel spreadsheet, and I'm going to summarize all of these 12 offers in this amazing, beautiful, color-coded Excel spreadsheet. This tab is going to be offer number 1, the key terms. Here's offer 2, the key terms. Here's offer 10, 11, 12, the key terms. I don't want to send all those PDFs over to my client. I'm just going to send them that Excel spreadsheet. Well, just a heads up on that, that is not consistent with Maryland law. Maryland law requires that all the offers be presented, not just a summary of the offers, not an Excel spreadsheet. And to the best of my knowledge, the Maryland Real Estate Commission hasn't dealt with this yet, but this one was in Washington State. They have an almost identical regulation requiring that the offers be presented in full and in writing. And in Washington State, an agent was disciplined. The agent was submitting the Excel spreadsheet to the client and not submitting the actual offers. So that agent was disciplined.
Can I chime in real quick? We were very specific. This was before your time when they came out with the regulation, but the statute says the same thing. It says specifically, unless the brokerage agreement specifies otherwise. So that's important, because if the seller or buyer, specifically the buyer, agrees that they'll get a summary, Maryland law allows that, right?
If the brokerage agreement says that, yes.
Yeah, exactly. I think that's an important point.
Yes.
Okay.
Yeah.
Thanks.
Thank you. Yeah, they can agree otherwise in the brokerage agreement. That's what's permissible. But absent that, they should be presented in full.
Thank you.
And I know, I think Dee, I think we've even talked about this. Sometimes an agent will prepare sort of a summary sheet or a term sheet on the first page, sort of summarizing the offer. That's fine. You can do that, but you still have to present the offer. You can do an Excel spreadsheet, but you still have to present the offer unless otherwise provided in the brokerage agreement. So thanks for the clarification, Chuck. Love letters, again, Colette touched on that in the presentation about the change in the forms. And that's, again, we've talked about that a lot for the past several, probably about a year or so, about love letters and potential fair housing issues by love letters. Again, the statewide forms addressed it. As of October 1, the buyer agency agreement and the listing agreement are going to be changed. So there's specific instructions in there where the client authorizes the agent to remove the love letter and not pass it along to the seller. So that should help. And again, the thought is that could be an educational opportunity for the agent to explain to to the client that they are obligated to follow the fair housing laws and to explain why a love letter could potentially be in violation. And the reality of that is it's very difficult. It's almost impossible to do a love letter that doesn't talk about or show a photo. It'll show a same-sex couple, a heterosexual couple, a family with children, someone's race, their national origin, all of those things that a seller should not be considering. All of those are almost always going to be included in a love letter, or certainly with a photo, a video. People are very creative in what they send. But again, the bottom line is that is dangerous ground to be on. It's risky for the agents. And again, sort of our overall conversation, we're all supposed to be promoting, we all want and we're committed to promoting fair housing, to making equal opportunities available for everyone to purchase housing. And love letters, it really just flies in the face of that concept and where we want to be. It kind of forces or asks the seller to consider things that they should not be considering. They should be considering the terms of the offer, period. So that's going to be addressed in the forms. The current market, again, waiving inspections. I'll go ahead and just say it, the as-is addendum. We had a lot of comments and questions about the as-is addendum, and I think there's going to be an article in the magazine about it. The concern, especially with the listing agent, was that some buyers agents were submitting offers with as-is addendum as a way to make the offer more attractive to the seller, so the seller would accept it. But the thought was, or the concern was, that there wasn't really ever an attempt to purchase the property as is. The buyer's agent was just using it as a way to make the offer more attractive. They would go ahead and do a home inspection, and the way the as-is addendum is written, that should be the end of it. It's the inspection is for informational purposes only. But what was happening in the real world is oftentimes buyer's agents were sending that over to the listing agent and asking them to make repairs or do this or give us a credit or do this, that, or the other. So the concern was that buyer's agents were sort of manipulating the as-is addendum or utilizing it for an improper purpose, which should not be happening. Obviously, we're supposed to be truthful. In every contract, there's a implied duty of good faith and fair dealing. So you shouldn't be using an as-is addendum if there's no intention that the property is going to be as is. So that was an issue, I guess, that was coming up. I think the real consequence of that, though, is regardless, if the buyer's agent sends over a copy of the home inspection report and sends it over to the listing agent, what happens with the listing agent? You know, can the listing agent, these are kind of the questions we were getting on the legal hotline, can the listing agent refuse to open it? Can the listing agent delete their email? And the answer to that, of course, the listing agent cannot. If the buyer's agent sends a copy of it over, the listing agent would be, deemed to have knowledge of what that included. So from that point forward, there may be a disclosure issue. It's possible there's no disclosure issue, depending on what's in the report. The bottom line, though, if the buyer has entered into an as-is, buyer and seller have entered into an as-is contract, if the buyer sends over a copy of the home inspection report and asks the seller to do something, the seller can say no. And what happens? The contract would remain in place as is unless the buyer terminates. So I've heard that again from teaching classes. I think some of the listing agents said basically if some transactions they had, the seller just had held firm and said, no, we signed an as is contract, we meant it, and that's what we're going to do. So we're not going to make any adjustments. We're not going to make a credit. We're not going to make any repairs. And this one agent in the class I just did last week, he said both buyers ended up proceeding anyway. They moved forward. They didn't terminate the contract. So just again, be aware that that's sort of an issue and it's coming up. And essentially, if it's possible that the seller and the listing agent will have to disclose something that comes up in that home inspection report. We're not a caveat emptor state. We are a disclosure state, and the seller does have obligations to disclose latent defects. Licensees, of course, have obligations to disclose material facts. So I think there's a little dissatisfaction with that, but that's unfortunately what's happening, or that's the way that as-is addendum has been utilized improperly, probably. The appraisal gap, we touched on that as well. Again, Bill had talked about it in the context of how an appraiser was valuing a home based on who owns it, the race of the person who owns it. In this context, we were talking about it again with respect to the current market, where there was a shortage of homes, and buyers really wanted to do all kinds of things to make their offer more appealing to a seller. And some buyers were doing their own addendum, or some agents were doing their own addendum. Colette, I think, had mentioned this. The statewide forms committee is looking at an appraisal gap, a way to kind of make that practice more uniform, to protect our clients and to protect us. If the buyer is going to offer more than the appraised value of the property, it's possible there may be some risk or some downside to that. If the buyer needs to sell their property within the next year, maybe they're not going to be able to sell it for what they paid. It's possible. It depends on what happens with the market. So that's what the statewide forms committee is going to look at. That's in review now. There's been some preliminary work on that, and as Colette had said, hopefully that'll be released with the October releases. This trend, I guess, cutting corners is sort of a broad concept, but I think there's a variety of ways that we're seeing this, again, based on the market. We've heard all kinds of situations. I heard of a listing agent. I guess there were counteroffers going back and forth. The listing agent was so busy, they were receiving other offers. They were asking the buyer's agent to prepare the counteroffer. Does anyone think that's a good idea? It's not, right? You should be preparing your client's offer. You shouldn't be asking the other agent to prepare your client's offer. So just a variety of things, but again, even whatever the market is, you have a fiduciary duty to your client. You have, I think Chuck had pointed out, there's a certain level of competence that's required, a certain level of knowledge that's required. If you're not able to provide that level of service or provide that type of service to your client, you should make a referral, refer that to somebody else, talk to your office manager or your broker, hire an assistant, hire a new member of your team, whatever you need to do. But that's not acceptable to be doing things like that. If you're too busy to prepare an offer on behalf of your client, you really need to have a heart-to-heart with your agent if they think that that's acceptable to ask the other agent to prepare the counteroffers. All right, then we have disclosures. This is again another one. It's sort of a perennial topic. I think this week I had a question about disclosure of alpacas. Someone wanted to have a couple of alpacas, and I guess there were some covenants affecting the community where, sometimes if the property is an acre, you can have up to a certain number of animals. You can have one horse or X number of alpacas. That apparently had not been disclosed, and the buyer was quite upset. She, I think, had 2 alpacas, and I believe it was a 1 alpaca community. So some of those things seem a little trivial, but the point is you need to, if you're the listing agent, find out what it's what you knew or should have known about the property. If the seller tells you there's covenants, if you have a copy of those, share those. I would suggest putting those up on Bright MLS, so anyone who's interested could see that. There may be restrictions on how the property can be utilized, the number of alpacas, whatever it is. Disclose, again, the disclosures always come up if the first buyer walks or terminates based on a home inspection. That's a pretty common situation, and that is oftentimes where it comes up. And the bottom line is that if the first buyer walks, the listing agent and the seller now have knowledge of things that they may not have had knowledge about before. In the best case scenario, the seller is going to do a disclosure. They're going to update their disclosure. They're going to include the new information. They now know there's an issue with A, B, or C. They'll update their disclosure. You would load the updated disclosure onto Bright MLS. If the seller is doing a disclaimer, that may not happen. In that case, the seller would just have to disclose any latent defects, which we know latent defects would be material defects that go toward health or safety and would not be readily visible if someone went through the property. So the seller would be required to disclose those. That's kind of the easy part. The harder part, the listing agent, as a licensee, the listing agent is required to disclose all material facts, and you would have to look at that property inspection report and see what's a material fact. And the listing agent is required to disclose material facts. And again, you guys do this all day, every day. Sometimes the seller may not like that, but the reality is your license requires you to disclose material facts. So
real quick on that, Kathleen, well, 2 things. First of all, Bill and Colette, if there's a lot of unanswered questions, you could dive in and just get to as many of those as possible, but a lot of them are forms. But Bill, there's probably a few in there that you can answer as well. On that specific point, Kathleen, Carol Sue says, and what we we see this a lot, which is we tell you what the law is, and then you tell us how you intend to get around it. And we love you, but so here's a new one. Seller expressly instructs listing agent to delete any emails received that indicate an inspection is attached And the listing agent does that and notifies the buyer agent that I just deleted the email, so I have no knowledge of the contents of the inspection report. The email is deleted. The listing agent never opens it. Is that a lawful instruction?
No.
Thank you. The answer is no.
No, we have two new attorneys in our legal department, Drew Kelly and James Bislity. And James used to work for a law firm that did E&O. They represented insurance companies and did a lot of E&O coverage. And that was something he specifically mentioned. Do not delete your emails. That if you go to court, if there's a lawsuit, it looks very bad if you have deleted your emails. You are not helping your case. You're not helping yourself. Of course, the seller doesn't want you to disclose. The seller thinks that the disclosure means they're not going to make as much money. In reality, I know this is hard for sellers to accept. In reality, disclosing is a little bit of an insurance policy. If the seller discloses a problem or an issue, then that means the buyer has awareness of it. The buyer has knowledge of it. The buyer is not going to be able to come back and sue the seller for not disclosing that. So I know that that can be a struggle. It's a difficult conversation to have. But the bottom line is there is some advantage to the seller as far as risk management or reducing their potential liability in making those disclosures, even if they don't see that at first, even if they don't want you to. And your license depends on you making those disclosures. Your license requires you to disclose material facts. And that's it. It's not worth jeopardizing your license because one client doesn't want you to make a disclosure. And certainly you should not be deleting emails because your seller wants to pretend that you never received this email. You guys know how IT works. It's very easy to, what do they call it? Forensics or whatever they call it. It's very easy to recreate that and determine that you did receive those emails, you did receive that, and that you deleted them. And that is not going to help your case in any way, shape, or form. So that was a good one, Chuck. Clearly, no.
Yeah, and could you
Catherine,
address,
go ahead.
Kenny, I'm sorry. Go ahead, Dee.
Okay, now there is one question over here that it's not forms related, but I think it is an important one to bring up to whoever wants to tackle this one, because we briefly discussed this recently about some of these services that people are now paying that are the show me service and how that's working.
That's the one that I was just going to ask
okay.
to address. Yeah, Kenny.
So I'm not sure who wants to address that, but.
I didn't see the question. That was my last slide. That was my last slide, so I just closed it.
We're told about a service where my business model is that I contact you and for a fee, I will show your listing to a prospective buyer and you give me $50 or whatever.
No.
Yeah, how many laws does that violate? And I thought we were going to call this to the attention of the Real Estate Commission without naming names. It's in the Q&A. It's in the question. I won't mention the name of the company, but no. Kathleen, you want?
Right. I mean, everybody think about it. Again, the brokers and the office managers, you should be aware of this. Remember a couple of years back, the Real Estate Commission in their commission check newsletter, they talked about agents from other companies holding your open house, sitting your open house. The listing agent is super busy, can't do their open house. They have a friend from another brokerage and their friend's new to the business. They want to help their friend out. They're going to ask their friend from another company to sit their open house. The Real Estate Commission was absolutely positively clear about that. No, that is not acceptable. As far as they're concerned, if that person is from a different brokerage, it's the same as being unlicensed. If they're going to be providing services on your behalf, they have to be affiliated with your company. And my understanding, Chuck, or anybody, if you disagree, chime in, but it's the same exact principle, the same exact rationale. Showing a property is providing real estate brokerage services. If someone's going to be providing real estate brokerage services on your behalf, you need to be affiliated with the same company. So someone from an outside company cannot do that. If they want to become affiliated with your brokerage, sure, knock yourself out. Pay them $50. Well, pay the broker $50 and the broker can pay them the $50. But an outside company cannot do that. That's contrary to Maryland law. It's not permissible. It doesn't matter if they can do it in Pennsylvania, they can do it in New Jersey, they can do it whatever they want. If the property's in Maryland, they have to follow Maryland law. And that is not permissible in Maryland. Anybody want to add anything?
I think that answers it.
Okay.
Pretty
All right.
clear.
We still have over 200 people present, so why don't anybody who sees a good question, either the chat or the Q&A. Like I said, as long as you guys are hanging in, and like I said, there's still more than 200 people on the call. So Go down the list. I've answered as many as I could typing, but there are probably still some good ones in either the chat or the Q&A that that don't have to do with alpacas. But thank you, Colin.
That was pretty good. There was one earlier, Colette can probably speak to this, that someone asked about back on the electronic lock boxes. And the question just was about, should it say electronic? And I think maybe that was not clear or wasn't understood what we were trying to achieve there, because someone else then asked about, was that going to cover, or were we only going to be covered liability wise if we are only using electronic lock boxes? And maybe talk about, Colette, the difference between what we meant by electronic and sellers saying, I don't want the box, I want to use the push button code or the garage code. Maybe that wasn't clear. That was in a couple different questions earlier.
Yeah, so there was a lot of back and forth about the type of lockbox that we're talking about. When Kathleen and I were going through the revisions, we initially had electronic lockbox in there, or reference to electronic lockbox, but as we had discussions with the statewide forms committee, they felt it was important to just leave the term lockbox sort of more generic, depending on the type of lockbox the agent or broker is using. The purpose of paragraph 4 is really to address those scenarios where the seller wants to use, you know, their own sort of security system or keypad or door keypad or something that's not what the broker or agent is utilizing, and to protect and the seller in those scenarios where they want to use their own system to protect agents and brokers if something happens. But again, there was a lot of discussion both between Kathleen and I and also with the statewide forms committee about whether or not we wanted to clarify the type of lockbox. And because there are different types of lockbox still being utilized, the committee felt at the end of the day, just leaving that term fairly generic was the better way to go. And Kathleen, you can chime in, or Dee Dee, I know you were in some of those discussions as well.
Yeah, go ahead, Kathleen.
I think that's it. I think Colette addressed that fully. It was just really intended to address a lot of people now, sellers have their own security systems, and just basically the broker is not in control of that, and there's some risk to that. So that's why that language was added. There's another one here about the deposit. Maybe I wasn't clear on that. It said there's an initial and an additional deposit. Are you saying there must be both, or one and or both? There's no legal requirement to have an EMD at all in Maryland. So there's no requirement that you have one initial and additional, whatever. There's no requirement to have an EMD at all. You can have an initial deposit of whatever, and that can be it. If you have the money in hand when the offer is submitted, you would say that's your deposit, you have it. I think a lot of times now, maybe you don't have, a lot of people are not using checks, or a lot of people are doing different things. Maybe it's someone from out of state, maybe they're purchasing property at Deep Creek, a second home. There's a variety of reasons why the deposit wouldn't be there when you're preparing the offer. So the way that it's set up is just a way to address that situation. It's possible you would submit the offer and you would have zero as your initial deposit because you don't have the check in hand yet. You don't have the wire in, whatever it is you're doing. You know that, you know, if the client's offer is accepted, they'll get that money to you within 3 days or something. So you could say initial deposit of zero, additional deposit of whatever amount you want to put within 3 days of contract acceptance. That would be a way to deal with that. But that's intended to be flexible. You can put no EMD at all. You can put zero for the additional deposit and a larger initial and additional, or you can put all of it as the initial with no additional. It just gives you flexibility with whatever your client's situation is and whatever works best for your client.
Great. And Kathleen, while we're also talking on the subject of EMDs, there was a question about the escrow agreement and it not specifying a timeline for the deposit being received or deposited. But I believe even though that's going to a third party as opposed to a brokerage, they would still fall under the guidelines of the state law. Is that correct?
They don't.
7-day.
They're not required to follow the Brokers Act because they're a title company. They're governed by the Insurance Administration. They don't fall under the provisions of the Brokers Act. I would suggest, though, that's a good reason to make sure that you follow up with the title company just to make sure that it is deposited. Colette, correct me if I'm wrong. I don't think there's anything in that agreement that says it has to be deposited within a certain time frame.
There is. Yeah, there is.
What
Yeah,
does it
there is. Yeah, it says it's handling the deposit provision. It says that the escrow agent agrees to deposit the monies within 7 business days.
Okay.
A lot of the language in that addendum tracks the language in the Brokers Act. So to the extent that it made sense to incorporate what was in the Brokers Act in that agreement, we did. So that's one of them.
Okay, good. So that's, I guess, Dee Dee, the clarification, it is the same requirement, but it's not because they're subject to the Brokers Act, but it's because.
Okay, I think part of it was also they were asking about how quickly for it to be received, which goes back to earlier when you were talking about, did the buyer go take it? Who took it? Who gave it to the title company?
Yeah,
So I'm not sure that's in there.
I would say follow up on that just to make sure.
Yeah.
Again, it's a terrible situation. I used to work at a brokerage and I have a very vivid memory of a bad situation. You do not, a listing agent, you don't want to have to look your seller in the eye and tell them that, oh, I never checked and I guess they never sent the EMD over. I mean,
despite the fact that it's in the escrow agreement, we've always taught that it's a best practice for, the listing agent, the buyer agent to confirm, where the deposit is. Did it get deposited where it's supposed to? I know I recently spoke with Lisa Cameron, who's our mediation provider. She's had several mediations recently where dealing with deposits where at the end of the day, close to settlement, it turned out that the buyer never submitted the earnest money deposit at all. So yes, the escrow agreement says what it says, but as Kathleen mentioned, you do want to make sure that you're confirming, making sure that you know where that earnest money deposit is, that it's been deposited. And that it's cleared, the check, whatever it is, has cleared and the money is where they're supposed to be.
I think someone had asked if there was an update on agents being paid at closing. I think that was addressed, but basically the guidance from the Real Estate Commission is that the agent cannot be paid directly at the table, even if the broker sends over the broker authorization, which previously was permissible. The Real Estate Commission clarified that is no longer permissible. And Chuck and Bill, I think that's something that our public policy and legislative folks might be looking at in 2022. All right.
I like Kevin Waterman's question about alpacas. No, going off that anyway. And it's the duty, the larger question is, what is our duty in terms of discovering covenants, restrictions, et cetera? And I can tell you that for as long as I've been with Maryland Realtors, 15 years now, we've made it very clear, and part of our mission is to protect our members and to make sure that they're not required, in fact, to do things outside of their control, especially when these are things of public record that are as accessible by consumers as they are by us. And so we have taken that position consistently, that, and it was the driving force behind the consumer notice that we ask you to give to consumers, because some people may care and some people may not. And Kevin's exactly right. If we start down that path, and this question I raised and Bill was there, we went to lunch with the Real Estate Commission because in fact, they by newsletter imposed on us. This was quite a few years ago now. Kathleen remembers it because she probably freaked out when she saw it when she was still working for the company, that we were required to look at the deeds and uncover all the covenants and restrictions. And we called the commission and we had lunch with them and said, where will it end? If it's this one, this month, what's next month? What's next month? What's the next obligation? What's the next duty we have? Where does it end? And every time we try to do something, if we do it wrong, we're liable. And so there was this never-ending stream of requirements on us. And we made it very clear to the Real Estate Commission that that's not our job. Our job is to give consumers information on which to make informed decisions. And so, no, it's not your job to review every deed, to review every covenant or restriction or condo document or anything else. It's not your job. Your job is to tell consumers, hey, if this is important to you, this is where you would go to get that information. So if you want 3 alpacas on your property, here's where you would go to find the information about whether that's legal or not. And so that's a very big distinction, and it's one we are committed to for protection of our members, that we need to put limits on what we're responsible for, and more importantly, what we're not.
I agree 1,000%, Chuck. I do remember that from the Real Estate Commission, and I worked with a brokerage, and I think my head exploded. I was like, that was not good. There's one question that's a good one, I think. Chuck, this will make your head explode. Some listing agents are uploading the seller HOA docs on the MLS, and they are using that to claim that the buyer agent has received them. Therefore, the 5-day time period to review has been fulfilled.
No.
Legitimate.
No, first of all, we have always said the statute doesn't say anything about the agent. Delivery from the seller to the buyer. 5 or 7 days does not start on delivery to an agent. That is, again, outside the scope of our agency. We are not lawyers. We are not, full agents in a sense. We're a special agency, and it's limited to things within the real estate transaction. And so, no, delivery to an agent is not delivery to this buyer. Time starts. There was another question about the acknowledgement. The acknowledgement is the same thing. It's to verify that the buyer, received the documents. But even if you don't have that, there are other ways to confirm that the buyer received the docs. And so, no, it has to be delivered to the buyer, ideally with an acknowledgement by the buyer that they were received on X date. But I've had situations where people said, well, I FedExed them and I have a buyer signature. I have a signature of the buyer that they received the package from FedEx. Is that sufficient proof of delivery to the buyer? And our answer up to this point has been yes. That's one way. The acknowledgement form that Maryland Realtors has published, but it's not the only way to confirm receipt by the buyer of the docs.
And Chuck, I'm going to ask a question now just for you. A situation that has come up, or we've been asked a couple of times, if the buyer receives the forms and they just sign saying that they've received the HOA docs or the condo docs, but they have not. They just signed it by accident. They didn't understand that they should not have signed it, or didn't understand what they're signing, and they send it back. Does that justify the listing agent saying, oh, well, I guess we don't have to provide the resale package to you because your buyer already signed something saying they had received it?
I don't know. I mean, if I think, yeah. I mean, if the buyer received,
They did.
well,
The buyer did-
I'm sorry. You're right.
They sign that line saying they
I know.
received.
Oh, yes, that has happened in the past.
All the time.
I would say if the buyer then would try to get out by virtue of not actually having received them, that they probably have a case. I mean, we can always say, well, why did you sign the document? But they'll pull the old whatever. I just want to say that there was in the chat that I'm wrong, that delivery to the buyer's agent is delivery to the buyer. I'm not wrong, John. I'm not wrong. I'm right. The statute says what it says. Delivery to the buyer. Delivery to the buyer's agent is not, under the statute, delivery to the buyer. No, it's not.
Right. And I was going to add as well, Chuck, that the statute says the protections to the buyer may not be waived, and anything in writing attempting to waive them is
Oh, that's a good point.
not valid.
Right.
So that's kind of what I was thinking about the if the buyer signs the acknowledgement saying they've received the documents when in fact they have not. Clearly it's sloppy and it's a mistake, and there's going to be some discussions, and it's not a great situation. But I think the fact is, under the statute, the buyer is entitled to receive the package. If the buyer does not, it can't be waived. So if they sign something by accident, I think the buyer has a good argument that it was just a mistake. It's not going to eliminate the seller's need to provide that resale package to the buyer.
Yeah, we've always taught that too, as far as HOA and condo disclosures and delivery. That's always been what we've taught in our classes.
Yeah. All right, what else do we have?
Well, John followed up by saying, so by your standard, which is not my standard, by the way, it's the standard in Maryland law, in the statute. So it's not my standard or our standard. It's Maryland law. Buyer's agent never delivers the docs. The buyer has not been delivered ever. Yeah, the answer is yes. And that buyer's agent who did not deliver the documents to the buyer should have their license revoked. Absolutely.
Someone had asked again about the EMD. If the contract does not need an EMD, can a seller demand some sort of EMD as an indication of good faith? What happens when there's a default with no EMD? I think the reality is, I think every contract does have a deposit just because that's sort of standard practice around here. And I think an offer with no EMD, no initial deposit, no additional deposit, no intent to ever pay a deposit, I think the seller would look upon that as I mean, it's just a perception, but maybe less credible or less of a serious offer than another one where someone's putting down $10,000. I just think that's the reality. That's how it would be perceived. So the seller could accept an offer that has an EMD. They could say they're not going to accept an offer unless there is an EMD, whatever they want to say, but just legally it's not required. I think oftentimes, as you know, there's sometimes a difference between the legal requirement and the real world situation, how it plays out. In this situation, even though it's not legally required, I think virtually every seller would expect that there would be some sort of deposit paid. So that might be one where the practical answer is the seller in essence really is requiring an EMD. But just to clarify, that the point we were trying to make is that legally it is not required that there be a deposit. All right. Anyone else that we want to hit? Or we're running over? Are we decently over or too much over?
Well, we still have 174 people. So if there are other questions, we can answer.
Yeah, a couple about delivery of condo or HOA still. Yeah, what happens if the buyer agent never delivers to the buyer? Buyer still has the right to get out of the contract. That would be true. We said the buyers, the protections afforded to the buyer, the rights afforded to the buyer cannot be waived. So that buyer's agent needs to be careful. There's, but for your, I don't want to say whatever negligence, whatever it is, your failure to deliver those to your client, that could result in the buyer terminating the contract, and the seller is not going to be happy, and the listing agent's not going to be happy. And if you sat on the documents for 10 days before you delivered them, is that diligent? Is that competent? I think there's potentially ethical problems, and you could be in trouble with the real estate commission.
Yeah, and here's the flaw in the thinking that delivery to an agent is delivery to the buyer under the law of agency. If this were an attorney-client and an attorney was actually allowed to make decisions for a client under a more general agency, I would say perhaps. However, in this special agency, I don't think anyone would argue, or maybe they would, if delivery to the agent is delivery to the buyer, then what you're saying in effect is that the buyer's agent should then be allowed to terminate the contract on behalf of the buyer. If you're counting the days, the 5 or 7 days to impugn that knowledge onto the buyer, even though the buyer hasn't seen the docs, only the agent has, then how can you count down the days to rescind the contract unless you also say that the buyer's agent has the right to terminate the contract on behalf of the buyer? And they can't. There's no way that can be true. So whether or not that appears in some form in Maryland, if it does, we would heartily disagree with that as a legal standard, and under that specific logic is why, in my opinion, it falls apart.
Are we ready to move away from HOA docs?
I think we
Yes,
can.
that's my last.
Okay.
There's
Okay,
one
here's
on
a good
first-time
one.
buyer. Oh, my
That's what I
God.
was going to say. That's a good one. Colette, you want to do this? Can you address the effect of the mandatory language in the code that the seller shall pay all state transfer tax when selling to a first-time home buyer when the parties have the buyer paying all transfer and recordation taxes in the contract? It appears to not be negotiable, unlike the recordation and county transfer taxes. So
Yeah, so that first time home buyer provision, I really want to be able to pull it up. Go on to a next one. Let me just pull it up and then I
okay.
can talk about it.
Okay, while she's pulling that up, Kathleen, someone actually, oh wait, I just lost it. Sorry, there's a lot of questions. Oh, here it was. There was one, because so this has come up recently too. You know how we had the authorization to sign things electronically and it was a whole form?
Mhm.
But then we've had the discussion that merely by the simple fact that you're in DocuSign and you're saying, yes, I agree to sign electronically and you're signing electronically. We don't need, they're asking, do we still need to incorporate that form or anything else? Because now there's actual paragraphs in the contract that do state electronic, means of electronic.
Yeah, you don't need a separate document or a separate paragraph. The language in the contract is sufficient. And that's also demonstrated or evidenced by the fact that your conduct is you are signing electronically, you're accepting electronic signatures. So it's both in the contract and you've accepted it by your conduct as well. So you don't need a separate agreement.
And while Colette's pulling that up, we could also discuss the need to not have the first time Maryland homebuyer addendum added into the contract.
That is a good one too.
Unless negotiated otherwise outside of paragraph 25 that Colette's gonna address above that right there.
Do you see paragraph 25 up?
Yes.
Yes.
Okay, so here's how we explain this 25B. The Statewide Forms Committee has gotten a number of proposals, try to clarify it, but I think if you read it, you get what the intent was. So 25B, first sentence under section 14104C, the real property article, right? This is a statement of the law. Under section 14104C, the real property article, the entire amount, liquidation and local transfer tax shall be paid by the seller of the property that's sold to a first-time Maryland home buyer, unless there's an express agreement that these liquidation tax or any state or local transfer tax will not be paid entirely by the seller. So this first sentence is a statement of the law that basically says the seller pays unless, this is a first-time home buyer, the seller pays unless there's an express agreement, all right? Again, it's a statement of the law. The second sentence that starts with if the buyer is a first-time Maryland home buyer, buyer and seller expressly agree. This is the express agreement where the parties are agreeing to do something other than having the seller pay. So this is the express agreement. I think that's kind of where sometimes the confusion comes. The first sentence is a statement of the law that says the seller pays unless there's an express agreement. The second sentence is the express agreement where the parties are agreeing in the contract that they're going to split these costs. So at bottom line, if the parties want to do something other than split, then they need to include the first-time homebuyer addendum. If the intent is that they're going to split, then they don't need the first-time homebuyer addendum, but they do need to check the box on page 10 that says the buyer is a first-time homebuyer. So hopefully, I don't know if that clarifies, and of course, you have the state transfer tax provision there, but I think that maybe is where that confusion lies a little bit. That's how we explain it when we teach it. All right, let me stop the share. Anybody want to add anything to that?
No. Oh, I'll mention one more. I just saw this question. What are your thoughts on delivering the property vacant at the time of settlement, as noted in paragraph 21, condition of the property in possession, where it's going to be delivered vacant and broom clean? I think the question is, does that mean that if it's tenant occupied, does that mean that the tenants will be evicted and they will not be living in the property? I think, was that Jim and Marie, I guess, that asked that question. Maybe I'm adding interpreting too much into that, but I had a question about that recently. Anybody, Chuck, I don't know, anybody want to answer that? In that paragraph, it says the property is going to be conveyed vacant and in broom clean, I think condition is what it says. And there's some question as to whether that means that if the tenant will be evicted, if the tenants should be removed from the property, if the buyer has the right to expect that the tenants will be gone because of the word vacant.
Well, I mean, at the end of the day, if the intent of the parties is to convey the property with a tenant being in it, then the parties need to use a tenant occupied addendum, which specifically says that the property will convey with a tenant in it. If the tenant occupied addendum is not included, then that does raise some issues with the property condition provision if it's not actually going to be conveyed broom clean and substantially in the same condition and clear of, whatever paragraph 2022 or whatever it is says. So I think the bottom line on that is if there is a tenant and the intent of the parties is to convey the property with the tenant in it, then they need to use the tenant occupied addendum. If that's not the intent, then that raises some issues with the property condition provision.
Yeah, I'll be honest. It never occurred to me that vacant in that paragraph referred to someone living in the property. I thought it meant that the boxes would be removed, the carpet would be removed, sort of, personal property type things. Generally in Maryland law, if there is a tenant at the property subject to a valid lease, unless, as Colette had said, unless there's some agreement to the contrary, the lease would continue upon the sale of the property, and the new owner would step into the shoes of the landlord. So absent some agreement to the contrary, the lease would continue. So I would just be cautious about the word vacant there. If it is tenant occupied, Colette's point is well taken. There really should be a conversation about what the expectations are. Is the landlord going to send the notice to quit to the tenant so they'll be out of the property before settlement? What if the tenant doesn't move out? Or is the buyer willing to extend settlement or wait until the eviction process is complete? But like I said, I'll be honest, I never interpreted that word vacant as referring to occupied. To me, that meant boxes would be removed or carpeting would be removed or personal property would be removed. But Colette's point is well taken in the question as well. If the property is tenant occupied, the parties need to have a conversation about what is supposed to happen. And we do have an addendum that Colette had just referenced, a tenant occupied addendum. It will really walk you through all of the things that should be addressed. What's going to happen to the security deposit? Is there a lease? Is the seller going to give a copy of the lease to the buyer? Is the security deposit going to be moved from the seller's side at settlement? It's going to go from the seller to the buyer. So the buyer will be the new landlord. The buyer will be the one returning the security deposit. It kind of walks you through what all the options are, and the party should definitely use that and make sure they're on the same page as to what's going to happen with those tenants. And even if they're not there, if their lease has expired, they still have the right to stay there. Even if they're a squatter, the owner doesn't have the right of self-help and to kick them out. There was a case where the real estate commission disciplined a buyer's agent who referred to the occupants as squatters. She told them they'd be gone by the time they purchased. It was easy to get rid of occupants. She knew someone at the sheriff's office. It was really going to be straightforward. Of course, an eviction is not easy. It is not straightforward. It is not quick. So that agent was disciplined. The buyers relied on that. They thought the occupants would be gone. They were not gone. And in fact, they actually were valid tenants. They had a legitimate lease. They weren't even squatters. So this is a topic to really be careful about and make sure that you have good communications between the buyer's agent and the listing agent. Make sure you guys are all on the same page and understand what's going to happen. You don't want any surprises. This is a tricky area and you have to be careful you negotiate it properly.
Yeah, and even squatters, that's a crazy term because Maryland law, gives occupants of properties rights under a lot of circumstances, even some that we might label as squatting. There still is a legal process very often. There was a big article in the Sun last weekend about that. Did you see that?
On Falls Road, yes.
The way mansion on Falls Road. That they moved and there was a moving truck and they changed the locks. And they moved into this vacant house. So, and they ended up, as far as I remember, they had to go through a legal process to actually get those, the sheriff out there and to formally evict them. So be very, very careful about when we use the word squatter. It sounds like we could just go in and shoo them out and change the locks and all, but I will say that a lot of these people do actually know the law. And this group in particular consider themselves outside the law, but even so, they know the law. And they know that, in fact, they did have certain rights that had to be legally addressed before they were ultimately evicted. So sovereign nationals. Yeah, thanks, Joe. Yes.
I'm not sure I'd say they know the law, but anyway.
Well, but they know
that's a
enough.
discussion.
And we've all had personal experience with people who know, and I have rights. Well, maybe.
Yeah, and that will likely be a subject of a bill this session too. There had been about 5 years ago, a bill that would expedite situations like this under the wrongful detainer statute.
Right.
That bill didn't go anywhere, so I'm not sure what will happen this year, but I would expect legislation on it given the press attention.
Hey, so Kathleen or Colette, I'm not sure which one to answer, but someone asked a very interesting question because we're doing a lot of post occupancies in our real estate world these days. Joanne's asking, do the terms of a post settlement occupancy agreement supersede the terms of the contract agreement? Question. That's a tricky one. It depends, right? That's your legal answer.
That's always our legal answer, Dee Dee.
Yeah.
Dee Dee just waved in. She passed the bar right there. I'm not sure what provision they would be talking about. That would is it in conflict with the contract, or I'm not sure exactly. I understand the context. Hopefully, they're not contradictory.
Yeah. Yeah, Maryland Realtors at this point doesn't have a post-settlement occupancy or a pre-settlement occupancy agreement. But yeah, what Kathleen's point is well taken is hopefully there's not a conflict between the contract and the post-settlement occupancy agreement. So you do have to, I mean, that kind of raises a good point about making sure there are not any internal inconsistencies with the contract and using any local board addenda that might have, might address provisions that are already included in the contract. So, if you are using a local board form or post-settlement occupancy agreement or something like that, you do want to kind of review it and make sure there's not anything in there that's conflicting with what the parties have already agreed to.
It may be property condition. Maybe that's what they're talking about. And I think you're probably talking about a G-car form, which I don't know all the terms of, but that might be what you're talking about, because the property condition might be different. If the seller's going to, like a post-settlement occupancy, the seller's going to stay there, that's going to affect the property condition paragraph as the property condition as of settlement versus as of when the seller turns it over. So just be careful, make sure your clients read that, you read it, talk to the title attorney or settlement attorney if there's any questions. Again, you just want to make sure that your parties understand what they've agreed to and what the expectations are.
Yeah.
And I think that might be what she's getting at, that let's say you closed in March and it hadn't been cold enough or warm enough to turn on the AC to test it. And they did a walkthrough, it still wasn't warm enough to test it. The sellers are there, and 5 days after closing, the AC unit doesn't work because it finally got warm enough for them to turn it on, So I think it might be, they're not talking live to us to answer if that's what Joanne means, but, that would lend itself to condition of the property as per the day of settlement. And now somebody else owns the house, but now something is actually broken in the house, and the owner was retained, the actual owner was retaining that license to still be there, right? But maybe not liable for their, they're not liable necessarily, depending on what it says, for the mechanicals of the house if something breaks at that point. So anyway, that may be it. That was the question.
We're coming up on 2.5 hours and still 140 people, but they seem to be dropping off. So, wow.
Yeah. And Joanne says correct. Apparently that's what she was getting at.
Amazing. Amazing. Thank you all for staying in, and thank you guys for participating. You want to wrap up for this for us, Dee Dee?
Yeah, we sure can. And I want to point out, someone asked earlier about getting some other panels together to have just kind of these ongoing discussions, just kind of Q&A sort of things. We do throughout the year. Please check the YouTube channel, Maryland Realtors YouTube channel. Colette, Kathleen, Bill, there's webinars that, and they're not necessarily webinars, but there are updates and things with videos that they are producing throughout the year that are discussing a lot of these topics and the updates of legislatively what's going on. This just lends itself to what Maryland Realtors, for the membership, some of the key things that are happening. You, as brokers and managers, over 200, there were almost, I think 250 at one point were actually on the call, and you just basically had full access of multiple attorneys. I'm obviously not an attorney, but you have all these attorneys sitting here, 4 of them, who have been answering questions and giving you opinions and walking through forms, which is one of our biggest benefits for the membership, are the statewide forms and of course the legal hotline. And I would encourage anyone who didn't get a question answered today, or we misinterpreted your question, or you have a suggestion for the forms committee, please submit those online to the legal hotline or through to the forms committee for discussion. I can assure you I've been on that committee, and when there's things that need to be discussed, every single thing gets discussed on those agendas and really discussed. So don't think that things are going overlooked, they're being overlooked, or things are going without notice, and they're just being kind of, skirted to the side. Everything really is addressed in many ways. And likewise with bill and public policy, we just don't come up with these things legislatively on our own, that we think that Maryland Realtors, needs to support, not support. New things that would be coming down, that we would need to create legislation, such as the pay at the table and all of that. These are things that we're addressing as an association, as a leadership team, as our wonderful staff at the state, to really be of service to the membership and to you as the brokers and managers. So I do encourage you, if we didn't answer your question or something wasn't clear today, reach out to any one of the panelists today, and everyone will be happy to get back to you. So on behalf of Maryland Realtors, I'll wrap it up. We thank you for being a participant today in the webinar. We appreciate your efforts, and enjoy the rest of the summer. And we'll hope to see you at the board meeting in September, and also at the convention in October. Thanks so much, everyone.
Thanks.